I expressly do not consent to this court's jurisdiction and do not.
Well, then you are not a named party. So if you're not consenting to this court's jurisdiction, sit down.
Oh,
you can go.
Oh, I see. So I need to.
I don't know what you need to do, but.
Well, let me respond.
To what? You're not consenting to the jurisdiction of this court. Why am I hearing from you?
I'm recanting.
You're recanting what?
What I just stated.
Which part?
The part that I lost my spot. Oh.
Well, no, it doesn't work that way.
Okay, I'm not really understanding, but I am nervous, quite nervous.
Today's courtroom drama centers around a woman accused of orchestrating a bizarre fraud involving a luxury home worth over $1 million. She's been living there rent-free, refusing to leave, and claiming she has the legal right to stay. But here's the twist. She's leaning hard into the sovereign citizen playbook, tossing around pseudo-legal jargon and imaginary rights like confetti. The plaintiff's attorney wastes no time laying out the facts, and it's immediately clear. This isn't just squatting. It's a tangled mess of deception dressed up as legal defiance. Her confidence walking into court is almost theatrical, considering how flimsy her claims are when held up to actual law. Now, squatter laws do exist in some states, and yes, they can offer limited protections. That's exactly why people like her try to exploit the gray areas. But this case goes far beyond that. What we're looking at here is a calculated fraud wrapped in sovereign citizen rhetoric, and it's unraveling fast. So here's the question. Should squatters have rights that allow cases like this to drag on? Or is it time to tighten the laws and close the loopholes? Let's break it down.
Ian Redmond, P70599, on behalf of the plaintiff.
And your name, ma'am?
Doshia Banks, occupant.
Pardon?
Doshia Banks, occupant.
Doshia Banks, occupant, Your Honor.
Okay. So you're not Ms. Whitlow?
No.
So what is your position in this case as you see it?
If I may, Your Honor.
Okay, good. Go ahead.
Ms. Banks claims to be an occupant of the property. She filed a bankruptcy case listing the property as hers. The bankruptcy stay was lifted, which gave rise to our motion to reopen the case. The order lifting stay I would like to present to the court because it has some interesting language in it, Your Honor, which includes, it is further ordered that the bankruptcy court finding this filing of this petition was part of a scheme to delay, hinder, and defraud VMC REO LLC. Additionally, Your Honor, the bankruptcy court ordered, notwithstanding Rule 4001A3, a bankruptcy rule,
Right.
creditor VMC REO LLC may execute on its order immediately. The order shall be binding and effective despite any conversion of this bankruptcy case to a case under any other chapter of Title 11 of the United States Bankruptcy Code. Further, that the recording with the appropriate governmental entity of this order shall constitute a bar to refiling any case under any chapter of Title 11 of the United States Code as to the property located at 5779 Pinecrest Estates Drive, Ann Arbor, Michigan. Wow. The property in this case. A debtor in subsequent case under this title may move from relief from this order based upon a change of circumstances or for good cause shown after notice and hearing. Said bar shall be for 2 years from the entry of this order or until such time creditor relinquishes their rights to the property. This order came out June 24th of this year. I have a copy for you. I will note, Your Honor, that Ms. Banks has filed an appeal of that order in the Federal Eastern District of Michigan. That appeal is pending, but the status quo as of right now is that there is no stay, and that order lifting stay holds until such time as the appellate court does something. Additionally, Your Honor, there is no stay from the appellate court. They have not issued a stay, and in fact, it would be appropriate that there would be a bond placed or an escrow order of some sort, because BMC has been the owner of this property for the past year and does not have access to it. Additionally, Your Honor,
There's more. Go ahead.
there's a lot going on.
Yeah.
Additionally, Your Honor, Ms. Whitlow, who, as far as I know, actually exists, but I don't have any evidence to that effect, has not appeared in any hearings in this court, did not appear for her deposition that she was noticed for in the federal case, and in a federal case, the federal court issued a show cause order to Ms. Whitlow that she had to present certain documents from this court, which she failed to do. Her deadline to do so was, I believe, July 3rd. Let me confirm that. Oh no, July 10th. And she did not supply any of those documents. I can present that show cause order if you would like.
I don't know that I need that, because
Okay.
I'm not.
The reason that I mention all of this, Your Honor,
Go ahead.
is that this is $1 million house in Ann Arbor that Ms. Whitlow purchased with a mortgage and less than a year later defaulted. The foreclosure went through, the sale occurred, the redemption period expired, and we came forward to evict. Since then, there have been multiple bankruptcies. Ms. Whitlow filed 2 different bankruptcy cases. A young man who apparently lives in Arizona filed a bankruptcy case and listed this property as his residence. Ms. Banks has filed a bankruptcy case and listed the property as her residence. It should also be noted that Ms. Banks was a bankruptcy preparer and has been forbidden from the bankruptcy court from preparing bankruptcies for anyone other than herself.
This isn't just a misunderstanding. It's a textbook example of fraud. Based on what's been presented, it looks like she impersonated a fictional couple. The Whitlows secured a mortgage on a high-end property, defaulted, and then tried to use bankruptcy filings to hold on to the house. The kicker? She's not even listed on the mortgage. Imagine borrowing someone's car, wrecking it, and then filing an insurance claim under their name. That's the level of absurdity we're dealing with. It's not just illegal. It's brazen. What's truly baffling is how she thought she could pull this off without leaving a trail. Mortgage applications, bankruptcy filings, these things generate mountains of paperwork. Investigators don't need to dig deep to find the inconsistencies. Once they start connecting the dots, the fraud glows like a neon sign. Judges aren't fooled by fancy words or sovereign slogans. They look for actual legal standing, and in this case, she has none. Her strategy seems to be flooding the system with bogus documents, hoping the chaos will buy her time. But the law doesn't bend for confusion. It cuts through it. So, is she genuinely unaware of how bad this looks? Or is she so deep into her own narrative that she thinks she can outmaneuver the system? Either way, if she keeps pushing, prison isn't just a possibility. It's a likely outcome.
I list all of these things to show that the scheme continues. And that's why we would like to reopen this case, because there is no stay in place. We would like to move forward with an immediate eviction, at most an 11-day vacate. And if for some reason that would not be amenable to the court, we would ask for an escrow order or a bond. On $1 million property, I think it would be reasonable that $10,000 a month rent would be reasonable.
All right. Thank you. Ma'am,
Yes, Your Honor?
what do you want to tell the court?
Well, just for 60 seconds, and then I wrote something up because I am nervous, quite nervous. But I, Doshia Banks, respectfully appear specially and conditionally for the sole purpose of protecting federally vested occupancy rights and opposing unlawful state action. I expressly do not consent to this court's jurisdiction and do not.
Well, then you are not a named party. So if you're not consenting to this court's jurisdiction, sit down.
Oh,
You can go because you're not a named party.
I have a lease.
You are not a named party on this. You may have a lease with someone else and then you can go challenge it. With who?
With Whitlow. Ms. Whitlow.
Then you need to go against Miss Whitlow.
Pardon me?
Then you may need to go against Miss Whitlow. But if you're not consenting to the jurisdiction of this court, you might as well just sit down. You are not a named party. I do not have to hear from you.
Oh, I see. So I need to.
I don't know what you need to do, but
Well, let me respond.
to what? You're not consenting to the jurisdiction of this court. Why am I hearing from you?
I'm recanting
You're recanting what?
what I just stated.
Which part?
The part that I stated that I'm not. Oh, I lost my spot. Not consenting to this court's jurisdiction. So I'm going to recant that
So you are consenting to this court's jurisdiction?
at this moment. Oh,
Well, no, it doesn't work that way. You don't get to say, well, now it's okay, and then not later say no.
okay.
You know what? Here's the problem. You've not filed anything with this court. So I don't know why, on those grounds, why I'm hearing from you.
Okay. If I may, I do have time, I do believe, to go file an answer and counterclaim. I was just led under
An
false
answer and counterclaim to what?
to their complaint for eviction.
You have a lease with, allegedly, with Miss Whitlow.
Correct.
Then that is who you need to pursue it against,
Okay. And
or whatever the heck you're doing.
well,
Because you don't have, there is no privity of contract to the extent there would be, or relationship as between the plaintiff in this case and you.
okay, I'm not really understanding, but
What she's attempting is one of the oldest tricks in the bankruptcy fraud playbook. Filing for bankruptcy triggers an automatic stay, a legal pause button that halts all debt collection efforts. That means no evictions, no repossessions, no wage garnishments. It's a powerful tool meant to protect people in genuine financial distress. But here's the problem. She's using it as a shield, not a solution. People who know they don't qualify often file anyway, just to stall proceedings. It's a delay tactic, nothing more. And courts have seen it all before. In her case, the filing bought her a few weeks of breathing room. But the cost? Potential years behind bars. It's a high-risk move that doesn't solve anything. It just kicks the can down the road. Judges are trained to spot these patterns. They know when someone's using the system to dodge accountability. And once the fraud becomes clear, the consequences escalate fast. What started as a pause can quickly turn into a criminal charge. So, was this a calculated move or a desperate last resort? Either way, it's not going to.
Let me put it a little bit more simply. If I grant the relief of the plaintiff in this case and grant an order of a judgment and an order of eviction in 10 days,
okay.
any claim of your interest in that property, you have to go after the Whitlows because that's the only person you have a contract with, allegedly have a contract with.
Okay. No, there is an actual contract.
I don't know that, ma'am.
We've actually been.
I don't know that.
Okay. I know you don't know that 'cause it's not before you.
Correct.
I see. So basically the notice of removal that the Whitlows did,
They are not here. I don't know. I have documents that are not, that they filed with this court that are not signed. So I don't have to accept them. She has not appeared before this court, or they have not appeared before this court. And so as far as I'm concerned, any relief they're requesting, I can, and as of right, deny, and it should be denied also on the merits of whatever the motion is. But I can deny it because they're not here.
Okay. Again, stating to me, I want to make sure I'm clear that my issue is with the Whitlows, not with VMC.
Ma'am, I am not giving you legal advice.
No, I
You're
don't.
telling me that you have a contract. I do not know that you have a contract, but if you wish to enforce that contract, that's who you're going to have the issue with. You're not going to have the issue with the plaintiff in this case because they have rights on the property.
All right, Your Honor, I will speak with the Whitlows that I have finally got an understanding of everything. And I will speak with plaintiff's attorney as well and continue to communicate with Remax, who has came by the house several times.
All right. Based upon the representation of counsel, I'm going to grant their motion to reopen this case. I'm going to issue a judgment in the plaintiff's favor for possession with a writ to issue 10 days of my signing. Should the matter be appealed, also contained in that judgment in order, the appeal bond I would set at this time at a rental rate or a rate, and I have looked at the property which is involved in this matter, and it is a significant property. I don't think the $10,000 a month quite does it based upon my calculations. So any appeal bond would be set in the amount of $15,000 per month that would need to be paid to maintain the appeal.
Thank you, Your Honor.
All right.
I will prepare that and present it to you this morning.
Thank you.
May I say something? Our lease payments was not that high at all. I'm not sure what her mortgage payments were. That was not our amount we paid.
Then I'll tell you what, if the Whitlows wish to come and object to my order of $15,000 as an appropriate bond, they may do so. I do not believe that you have standing to object to the court's order. Thank you.
Thank you, Your Honor.
Thank you. Take that.
I know,
and
you didn't write anything.
We'll await. I did.
Oh,
No.
no, I don't think so.
When she walked out of the courtroom without even challenging the judge's ruling, it spoke volumes. Maybe she realized the fictional Whitlows couldn't be defended. Maybe she knew pushing further would only dig the hole deeper. There's something off here. This isn't just squatting. It's entitlement, layered with deception. And the moment that really stood out, her complaint that $15,000 a month was too much, as if she was negotiating rent instead of facing a fraud charge in front of a judge. This mindset, where squatters believe they're above the law, is part of a growing trend. People exploiting legal loopholes to live in homes they don't own, while the system struggles to keep up. It's frustrating, it's costly, and it wastes valuable court time. Judge Simpson showed remarkable patience, but at some point, the tolerance runs out. When the paperwork is nonsense and the story doesn't add up, the fraud charge becomes inevitable. So here's the final question. Should she face prison time for this elaborate scheme? Or should the system simply evict and move on? Drop your thoughts below, because this case isn't just about one woman. It's about how far people will go when they think the law can't touch them.